Okay, actually, I've just noticed we've got a couple of hands up. I will just have a look. Anna, let's hear you. How can I answer your question?
Hi, can you hear me?
I can, and I'm very pleased
Great.
to hear you.
So in the Australian Wool and Mills case, I just wondered if you could argue that maybe there's an economic benefit as part of the policy that maybe could form part of the exchange.
Absolutely. So I'm just going to mute you again now for a second. The issue is not whether or not there's an economic benefit, though. It doesn't go to the sufficiency or adequacy of the promise. In part, it goes to timing. It's complicated, though, by this being a policy, so as opposed to a promise as well. And you'll see we'll come back over and over again to examples of failed formation where there is no contract, in part because we're dealing with a government. We're dealing with a government organisation. And that means that the making of the contract needs to be significantly clearer. But yeah, look, at the end of the day, AWM was doing exactly what it was that the government of the day was trying to encourage by that kind of behaviour. And to an extent, the purchasing of the wool was in reliance on the idea that, well, I'm spending 10 quid a bale, but I'm going to get 1 quid back from the government, so my actual price is 9 quid or whatever it happened to be. Don't quote the numbers back at me, please. But that was an aside. The reason they bought the wool was because they were wool manufacturers and they needed to fulfill orders for the blankets or coats or socks or whatever it is that they were making. So, Anna, does that answer your question?
Yes, no, I don't know, it just makes me think more that it goes back to the power thing where it's kind of, because it's a government organisation, they can kind of do what they want.
Well, look, we do have a separation of powers. So, in theory, and in practice, largely, the government is separate from the courts, and the courts are deciding on what they can and they can't do. There are some constitutional limits to the way that government organisations can contract. And we will look later on, particularly when we look at, there's a case that's called something like Lay and the Administrator for the Territory of Papua New Guinea, or something like that, which looks also at that word about policy. So part of the question here also goes to, was it a promise to pay the amount, or was it a policy of paying an amount in a particular set of circumstances? Because it has a unilateral element to it. But have a look at the case and see how you go with it.
Okay, thanks.
Anybody else with their hand up there? Doesn't look like it. Okay. Sorry, I've just got the same slide that we spoke about before, and we are at 7:46, and I want to make sure I get through the key things before we get into next week. Though we'll have plenty of time next week too. So, core rules of consideration needs to move from the promisee. It needs to be sufficient, but it doesn't need to be adequate. Past consideration is not good consideration. Performance of or promise to perform an existing legal duty is not sufficient consideration. And part payment of a debt is not good consideration for a promise to waive the debt. So each of those we're going to deal with in significantly more detail next week, but it's worth just having these core rules at the back of your head. And I know it's unfair at the moment because we haven't delved into what each of them means in any detail yet, but I want you to just have them at hand as we think more about what consideration means. So ultimately, this will be about this ongoing test of, is the consideration, if there is consideration, is it good consideration? Is it legally sufficient consideration? and we've got to get an understanding of what legally sufficient consideration means. So, in fact, I think I made these points earlier when I was talking about moving from the promisee. I don't really have anything extra to add here, and I again will circle back to this when we talk about privity. I've said topic 8, but I'm not exactly sure if the topic number is the same, but we will be talking about privity. The difference between adequate consideration and sufficient consideration. Consideration needs to be something the law regards as valuable, but it doesn't require parity in value to the promise. So nominal consideration can be sufficient. Key cases here are Thomas and Thomas and the Chappell and Nestle case. So where throwaway chocolate wrappers, so Charlie and the Chocolate Factory type golden wrappers, could be sufficient consideration for quite a large amount of money, even though really they're just meaningless pieces of paper. The case I'd really like you to focus on here is Woolworths and Kelly. So this is a decision of Justice Kirby. In fact, it says Justice Kirby here, but it's a New South Wales Court of Appeal decision from memory. Somebody can correct me if I'm wrong. And so I'm thinking it should probably say President Kirby, Kirby P instead. And I think this is a really useful decision to get a solid understanding of what consideration is and why it needs to be sufficient but doesn't need to be adequate. So Kirby actually goes through, and there's, each of the points are here in a different colour on the slide, as to why it would be inefficient for a court to try and work out whether consideration was adequate or not, and why it is important for efficacy and for the efficiency of the way the courts work for judges not to do that thing. So he talks about how it's impossible to evaluate the equivalence of promises. What is valuable to one person may not be objectively valuable to another person. What kind of test do you use to establish value? Given, in theory at least, every single contract is a private law, a bargain between individuals coming from different places. He also points out that judges and lawyers are not really qualified to opine on the wisdom of a deal. Whether it's a good deal or a bad deal is not what the courts are for. What the courts are for is to apply the rules in a particular way so that we can know what will happen if there is a breach of a contract or whether a contract exists. If everybody could rely on a court to determine whether or not it was a good or a bad deal, then anybody who was unhappy with the way things worked out over time could just go to court and get judges to argue or to listen to their arguments about why it was a stupid deal in the first place. The evidence burden on the courts would be ridiculous. Imagine all of the experts that you would need to establish it's a good deal or a bad deal. And that would slow down the courts even more than they are slowed down today. He also talked about the extent to which this kind of evidence would lead to uncertainty into the enforceability of contracts. And also comes right back to this original idea that we started with at the very beginning of a contract being a private law and that parties should be free to make their own deals. And that these days has an overlay attached to it of the extent to which we have a Trade Practices Act or other legislation that goes to fairness, that the contracts law itself doesn't need specifically to think about fairness. So, it is criticised quite heavily though. It's criticised as being anachronistic. It's criticised as being a constraint on the freedom of promising and contrary to business practice. People don't always work out what the consideration is, and people will often do things as a consequence of things that were done in the past. even though there is no direct promise there. Since as long ago as 1937, law reform committees, in particular the UK Law Revision Committee, has been making recommendations that if a promise is in writing, that should be enough. You shouldn't need to pay consideration for a promise if it's in writing. And in the UK, consideration is no longer required from memory for options, agreements to accept a lesser sum, or anticipated detrimental reliance. The Australian approach to promissory estoppel overcomes some of these problems, but promissory estoppel is a remedy. That means in order to be able to get the benefit of a promissory estoppel argument, you actually need to go to the court and take your risk. So there are laws that try and avoid this consideration problem. For example, we have misrepresentation in tort, breaches of statutory prohibitions under the Australian Consumer Law, which includes the unfair contracts legislation and the Thou Shalt Not in Trade or Commerce act in a way that's misleading or deceptive. The law of trust helps to an extent, and then we've got these remedies, restitution and estoppel, that you will deal with in subsequent subjects. But at the end of the day, again, it is just worth thinking about that question, do we really need consideration in this day and age? So, what do you think? Rather than go into the thing that I'm just getting exhausted by all this stuff going backwards and forwards, anybody want to share any ideas about what you think about consideration? I'll bring up the chat so we can all see it. But if you put up your hand, I'm really, really happy to hear your voice. And I can see there are some questions along the way in writing here, which I'll deal with when we get to the end. But specifically, do we think consideration is a good idea or a bad idea? So Nahida is saying all parties involved know their obligation in the agreement, so we can ensure all parties gain something from the contract and uphold their rights with the contract. I think theoretically that's right, but again, when we raise the point that it just needs to be sufficient, not adequate, I can be held to a significant promise that I made because there was peppercorn consideration for it. Or on the other hand, like in Beaton and McDivitt, I can live on some land for 7 years. I can add a house to it. I can raise crops on it and then summarily be kicked out because the promise that was originally made to me that they'd transfer the land to me one day wasn't supported by consideration. That the things I did since were extra things that I did. There wasn't any exchange in the bargain. Marius says something quite similar. Yeah, look, it is hard to wrap your head around the concept at this stage. I am asking you to trust me to a certain extent that it will flip in. And when we look at more and more examples next week of the different kinds of exceptions in the contracts and the way that they're dealt with in consideration, hopefully it'll slip in to play. But of course we're breaking down, we're looking at these different jigsaw pieces as if they were entirely separate concepts, and they're not, they're interrelated with each other. And so we're going to keep going backwards and forwards, and then suddenly you'll get there and say,